The judge has ruled that the text messages between Brett Howden and Taylor Radish are inadmissible as evidence. This is part 1 of my Day 23 recap of the 2018 Team Canada SA trial. If you're new here, I'm providing daily updates on this case, so make sure you follow so you never miss anything, and all events discussed in this video are still alleged at this time. To explain her ruling, the judge said a text message, quote, sent to a friend is not a statement made under oath. She also said that while Howden testified, he wasn't trying to lie. He believed he was being truthful when he texted those messages, but she said that he didn't testify that those messages were true. In response to this, the Crown Attorney is seeking another legal avenue to get those text messages admitted into evidence. The Crown Attorney then went on to address the judge, explaining why that she believed the text messages should be entered into evidence. The attorney said that Howden seemed ready to adopt many of the prior statements that he made. While testifying, the Crown has been asking Howden about certain incidents or details relating to the alleged assaults. When Howden has said that he couldn't recall the details, the Crown has asked him to refer to prior statements he made to interviews with investigators. And when he referred to those statements, Howden often testified that he still couldn't recall the details. The Crown said, quote, the Crown should be afforded an opportunity to advance all legitimate avenues for putting this important information into evidence in the trial. The lawyer for Carhart tried to counter this, saying that the Crown knew Howden had serious memory issues and that for more than a year the Crown has said it was not seeking to introduce these text messages as evidence. He also went on to say that there were weeks and weeks of court time set aside to deal with the issue of entering the text messages as evidence. He also went on to say that the defense would have cross-examined differently the two former witnesses who were Taylor Radish and Tyler Steenbergen if their text messages were going to be entered into evidence. The Crown basically then went on to say that the defense has brought up this issue of the Crown knowing for a long time that Howden has had memory issues, but she went on to say that the Crown expected that Howden's memory would be refreshed and that he would be able to testify about the things that he had said before when they happened. She said, quote, memories can be refreshed. This has always been a fluid issue. The Crown Attorney then went on to say that the Crown didn't know that it would need to make substantive use of the text messages, and if Howden testified that he saw Dylan Dubé slap the complainant, the text message would have been admissible. The judge then ruled that she will allow the Crown to bring forth a new legal application to try and enter the text messages into evidence. The Crown then went on to talk about the accuracy of Howden's text messages. The attorney said that it's reasonable to conclude Howden would not have said this unless that the message is true and accurate because it reflects poorly on Dubé. There is no reason to fabricate or exaggerate to make things worse than they already were, as there was a Hockey Canada investigation going on. The words in the text are, quote, clear and unambiguous. She then went on to say that it, quote, defies coincidence that Howden would be lying or mistaken about Dubé slapping the complainant's buttocks, since the Crown witness Tyler Steenbergen, who was an ex-teammate, said he had seen Dubé slap the complainant. The Crown Attorney then noted that Steenbergen said it wasn't hard, but it didn't seem soft either. The Crown Attorney said that the only explanation of Howden writing the text message was that he was telling the truth and accurately describing what he saw.